And instead, the refrain comes out very frequently from counsel, unless there's a specific statute that says that you have to or you can, you might get sued if you don't. And very frequently, that's enough to prompt regulators to do nothing.
I don't have to read a law review article, but I would imagine that if you compared the 50 states, California does pretty well on volumes of consumer protections that we have. Although they may not be specific. I don't know if North Carolina Dental, they're asking, they say, where's the basis? Has the legislature spoken on this? We've taken lots of actions on cars and you name it to protect the consumer. For you and I, we may have some more ideas of what we want to do, but I think the boards have some wealth of the law where they can make the tie to say, well, this is the instruction that we think we got from the legislature.
They do. Clearly, let's take the example from yesterday of the veterinary board. Clearly, the veterinary board would not have been thinking about these regulations, because they were regulations, unless there were some putative statutory authority for those regulations. The problem is, it shifts the entire risk calculation for these individual board members. Remember, the Attorney General's opinion says he can't guarantee you that these individual board members are not on the hook if there are punitive damages. So, why would they have removed something from the front? Why would a regulation, which by definition has some sort of statutory basis, because the downside is huge. If you get it wrong, the downside is huge. It is potentially money out of your own pocket, and it is potentially, even if there is indemnity, treble damages out of the pocket of the state treasury. So if you take a naturally risk-averse environment and then you add in even the remote possibility of treble damages, the inability to be able to assure that you're not going to get sued, and you're talking about potential liability for the state treasury to boot, that is a recipe, in our opinion, for inaction, even when the grounds may be very compelling. And when you compare that, Senator, to the very modest kinds of legislative proposals that we've outlined, or the Attorney General's outlined, or DC has outlined, when you combine that downside with the modest proposals that are required to fix it, we think that's a recipe for action this next legislative year.
But you don't think that the legislature at some time, I mean, these lawsuits don't happen overnight. These conflicts, I mean, North Carolina the legislature had 5, 6, 8 years to step in, that you don't think when we have our normal review that we'd say this is a, beige area. Not even, it's not crystal clear, but we'd feel, as we ask some judges to make comfort orders, we say, well, we'd like to have the legislature to weigh in specifically on this to say, that's what we had in mind when we passed that Consumer Protection Act.
There's no question that that's true. But I think consumer protection demands that we not have to wait for the legislature to bless a board going after unlicensed practice. Sure. If there's a danger to the public right now, we want them to be able to go after them without fear of having a piece of paper with lines on it, with their name on it, with the possibility of treble damages. And that's really all this is frankly about.
Thank you, Senator Wieckowski. Other questions, comments? Mr. Howard, I had one. You referenced in your letter that you had sent about the California Board of Accountancy.
Yeah.
And I thought that was interesting because you kind of addressed the board continues to administer the Uniform Certified Public Accountant examination as a prerequisite to CPA licensure in California, and that test is wholly controlled by the American Institute of Certified Public Accountants, a trade association, and so they determine whether you pass the test or don't pass the test. And do you feel that, are you more concerned that the exam is controlled by the trade association, or that the Board of Accountancy fails to supervise and oversee that exam?
Exactly, both in combination. There is nothing inherently illegal, although unwise, but illegal about a state agency deciding to use an exam prepared by anybody, including market participants. But what the court decisions teach is that, and I think it was Senators Block and Wieckowski were talking about the factual basis of the decision. What matters is whether or not the regulator is sort of just blindly deferring to the industry not even really looking at it. It's a fact-intensive inquiry about whether or not the state, in the form of the Board of Accountancy, is in a searching way actually making sure that what the market participants are doing isn't anti-competitive. And coming all the way back with respect to talk legalese for a moment, coming all the way back to the risk, to the ability to file a lawsuit, because these are very fact-intensive inquiries about whether or not there's a really anti-competitive motive or not, it means that they are inquiry, it means that these are lawsuits that cannot be thrown out on either demur or 12b-6. It means that these are lawsuits that, if pled correctly, are going to move at least to the summary judgment stage, precisely because these are fact-intensive inquiries. It could very well be that you have a lawsuit that alleges that there is insufficient market participation because of the way that the Board of Accountancy reviews it, but you wouldn't be able, if you had a halfway decent lawyer doing the pleading, you wouldn't be able to get that kicked out of court at the very beginning. You have to try it a little bit. And that means attorneys. By the way, we all know that the DCA boards pay the Attorney General an hourly rate, right? Because that goes into their decision-making about whether or not they're going to do something that might get them sued. I hope that answered your question, Mr.
Yeah, no, it did, very much so. And you also, I think, mentioned in here about the Office of Administrative Hearings having some involvement.
Office of Administrative Law, Mr. Chairman.
That you meant the Administrative Law, okay.
By the way, just to amplify that quickly, we did debate when we were discussing what to propose to the committees, placing those same duties within the Department of Consumer Affairs. And the reason why we elected to do the office, or recommend the Office of Administrative Law is two things. Yes, one of them is mostly 6 of 1. But the second is that, or I guess on the 6 or 1 part, that the office is already in the business of comprehensively reviewing regulations in a way that the department is not, frankly, as you heard from the director. They've not vetoed regulatory packages in a long time. It's more common for OAL. The second is in looking to try and create basically a litigation defense, the Office of Administrative Law has a term appointment. It's a term appointment, whereas the director does not. So there is more independence there than there would be with the director, not to cast any aspersion on the director here or any other director, but it is a term appointment, and the reason for that is precisely when they created the OAL to give it some more independence to be able to do unpopular things, like overriding, one of the boards that are within the department.
Okay, Mr. Howard, thank you very much.
Thank you so much, Mr.
Appreciate
Chairman.
the testimony, appreciate the letter. And you did, Mr. Howard made some comments related to the Veterinary Board and the decisions yesterday. So I know there's Veterinary Board representatives that if they'd like to kind of say something, and maybe the director would like to clarify too, just to make sure that. Very good, thank you. Just to clarify, and then we do have public comment, and will be included in public comment today, so thank you.
Thank you. Thank you for your time. I'd like to correct, my name is Anne Marie Delmanayo. I'm actually the executive officer for the Veterinary Medical Board. I have with me Kathy Bowler. She's a public member of our board. We actually held our board meeting this week, and animal rehabilitation was one of the many issues we discussed at our board meeting. In fact, we took in several comments about the animal rehabilitation regulations. And those comments, some were in fact, of a non-competitive nature. What is the Veterinary Medical Board doing to potentially maybe limit or prohibit non-veterinarians from working with animals in the rehabilitative realm? The reason the board was adamant about taking additional comments in addition to the public comment hearing that we held on September 21st, is that we really want to hear from those interested folks. We made a decision at this board meeting this week to withdraw the regulations from the OAL process so that we could continue to work on this proposal to make it just that, much more in line with consumer protection and an overall view of what animal rehabilitation is in the realm of complementary services that many consumers choose for their animals. So it is exactly what Mr. Howard suggested that we do as regulators and as regulatory agencies, and that is to hear from those interested parties who are they are market participants, but they're not licensed market participants. So we feel very strongly that we are doing just that as a regulatory board. Our meetings are webcast. We are open to the public. We encourage public participation. We reach out to interested parties and we invite them to participate in these discussions and actually engage in this conversation with these decision makers. So I feel very strongly that we upheld our responsibility before the public and we spoke to Mr. Howard's concerns. Thank you.
Thank you.
And I would just like to submit that I think our meetings the last couple of days, and particularly on this issue of animal rehabilitation, should provide us with a good feeling about how the boards work in California. It was very, very collaborative, very deliberative, and it is a growing field of care for animals that is engaged in all along the way by many different folks, and some of it is from everything from acupuncture to acupressure to hydrotherapy to all these different modalities that we all want to be able to do for our pets. And so I think the reason we postponed it had really nothing to do with the anti-competitiveness or risk aversion. We really want to get it right, and we want the regulation to be formulated in a way that can come before, get the regulation done in a way that suits Californians, our pets, and all the consumers and the licensees. So that's really why. We just wanted to clarify that.
Thank you for clarifying.
Thank you.
And also, thank you for your public service in this regard.
Thank you. I
Thank you
love it.
very much. Appreciate your time.
Thank you so much. This is public comment. If anyone would care to make a comment in the public, please come forward. Thank you, Senator Wieckowski. Good afternoon. Hi.
Good afternoon, Chair and members. Brianna Pittman with the California Dental Association. Just want to say that I, want to thank you for the discussion today and the legislature's interest in making sure that our DCA board structure are set up in a way that we're not putting our boards at risk and that they are able to, do what they are charged with doing, which is protecting the public. And I also really appreciate all the discussion highlighting the differences between North Carolina and their dental board of examiners and the California structure here, including in the composition, the appointment process, their authority, and the state oversight. And just want to acknowledge our dental board here in California, both the dentist and the non-dentist members, for their thoughtful processes that they engage in and the fact that they are not, in fact, a rogue dental board. So as the dialogue goes forward on what changes, if any, are needed, we really look forward to being a part of that conversation. So thank you.
If I wanted to go into the business of teeth whitening, I could do it in California? I'm kidding. I don't need an answer, thank you. Yeah, Gloria.
Alicia Sanchez, representing the California Medical Association. We too want to thank you for looking into this question. As my colleague from the Dental Association mentioned, we all want to ensure that our boards are doing the due diligence to protect the public. And we, I think, have been talking about what that means in terms of kind of theoretical instances, but I do want to make sure that it's clear what we are talking about. In fact, the medical board has been, looking and has done a lot of good work in looking at unlicensed practice of medicine. And in one case where the individual was found guilty of criminal charges, he advised a woman with an autoimmune disease to surgically extract all of her teeth. And ultimately, the patient paid $32,000 for that service, which was ineffective in treatment. So this is the kind of thing that we're talking about in the context of public protection. And there are times at which antitrust or anti-competitiveness may be in conflict with the state's interest in protecting the public. And so that's why I think it's so important that so much of the testimony hinged on this idea of state oversight and active oversight. And we do believe that the state has done quite a good job and that the boards have, and the legislature has ensured that the boards continue to address that patient protection goal and mission. And so we also look forward to whatever conversation moves forward and hope to be a part of that process. And thank you for your time.
Well, thanks for the testimony. Thanks for being here today.
Mr. Chair, Good afternoon, Mr. Chair, members of the committee. Stephanie Roberson on behalf of the California Nurses Association. Thank you so much for convening this conversation, and we appreciate being part of it. Thank you for letting me speak in public comment. I just want to highlight, and this has been brought up by other panel members, but just want the legislature to know that they should have some comfort in knowing that the state has many mechanisms by which healing arts boards are actively supervised. Licensees and other members who serve on DCA boards are vetted through the governor to ensure that they possess expertise specific and that's required by law. And also the pro tem and speaker also vet candidates. This is much different than the supermajority of licensee members on North Carolina Board of Dental Examiners who were selected to serve by a vote of their peers. Healing arts boards and other public boards are scrutinized very closely by the sunset review process conducted by the legislature, led by our chair here, and also Chairman Bonilla in the Assembly. Of both houses, these committees look at licensing, disciplinary, rulemaking, and internal administrative activities. For the purpose of rulemaking under the Administrative Procedures Act, review and approval by the DCA director for most and newly and amended regulations proposed by healing arts boards also are on the table. And this happens for law inconsistency purposes for statutory mandates. Licensing and disciplinary decisions and other actions by the boards are subject to judicial review in the California courts under the Civil Code of Procedure. So these are some of the things by which checks and balances do happen in the state, and CNA fully supports the other remedies that were brought up by DCA and the AG on recommendations to try to tighten this up. As the AG opinion makes clear, radical changes to the composition of the boards are very unlikely to do anything to resolve the question of state immunity, which ultimately is the question in this case. The case is not about policy or what the composition of state boards should or should not be. To date, we don't believe that there are any antitrust lawsuits pending in the state. If so, we don't believe that this happens very often. So careful review of this matter seems more appropriate at this time. Just a note, it's very hard to find public members to fill these slots on many of these healing arts boards. We hear it all of the time. So we know it's hard for public members to invest the time that it takes to serve on these boards. And we know that the time that is invested by public members who do serve and the licensees who also serve are for the public protection. So we know that that's necessary. Having a board composed mostly of professionals enhances public confidence in the board, since most consumers will prefer practitioners themselves with the expertise to make decisions about who is and who is not fit to practice in this state. So with that, we want to continue in the conversation, and we appreciate the time to speak today. Thank you.
Thank you, Ms. Roberson. Other members of the public would like to comment? Yes, ma'am. Please come forward. Welcome. Hi.
Hi, my name is Carrie Ann Calais, and I am a California citizen and voter. I wanted to thank the committee the Joint Committee for inquiring into these issues. And I just wanted to offer a couple of my thoughts as a voter. It's important to me that the California legislature, one, requires boards to be justly constituted and fairly representative of both public and professional concerns, with transparent selection of board members, term limits, and some possibility of replacing unsuitable board members. Two, that the California legislature requires boards to be protected from the undue influence of and prohibited from unfair collaboration with outside organizations of the professions they regulate. And three, California legislature should see that all regulatory boards are actively monitored for problems by an independent entity clearly responsible to the public interest. Four, is that the California legislature should establish that its regulatory boards, whether they cannot or they can be guaranteed to be fair, impartial, and free of anti-competitive behaviors, that such boards be held in some way responsible for their actions, especially because these boards are not elected by the public, or as an alternative to implement some sort of appeal or review mechanism. 5, require boards to document their actions and preserve evidence so that it's available to support the regulations they promulgate. I also wanted to say that I was so glad to hear from various members of the California government here today, because it shows that people in the government are really concerned about finding a way to make sure that regulations put forward are fair. And I can see from the Office of Administrative Law, the Department of Consumer Affairs, the Vet Board, from the Attorney General, I can see that everybody's thinking about this and really trying to make things fair. So I wanted to thank everybody who's testified here, and it's important. It's an important issue, and that's all I had to say. Thank you so much.
Said it very well. Thank you for coming today and for your testimony. Others? Seeing no one else, Assemblymember Jones, would you like some final comments?
I just want to thank you, Senator Hill, and the other senators, and Assemblyman Dodd, and of course all the staff that were here today. I think this was a good discussion, and we'll probably be looking forward to continuing it and making sure that we're effective moving forward. Thank you.
Good. Thank you very much. Senator Block.
Thank you, Mr. Chair. You know, looking out here and seeing Kathy Bowler, who testified, and Frank Ruffino there, and others, I'm sure, who are public members of boards, a concern I have is the indemnification issue. I mean, we don't want the state to protect people who are evildoers on these boards, but on the other hand, we have a lot of citizens who in good faith are giving of their time and their expertise to help the state, to help consumers. And we want to make sure that we protect these board members. The early discussion, the AG's office discussed it, and I think the Department of Consumer Affairs discussed it too. There is clearly a balance in indemnification here. I don't want board members who are making a decision that they think will protect the public to be chilled in their action because they're afraid that they and their families might suffer a lawsuit because of their action. I think much better for the state to protect a very, very, very few who might purposely do something wrong than to limit protection to the great number of people who are acting on the public's behalf and as a result show their willingness to work for the public. So I just want to get that out there. That's not a well-formulated, no legislation in that, but just a word of where I am on this important issue of indemnifying board members.
Thank you, Senator Block. Assemblymember Dodd. Senator Galgiani.
I appreciated the hearing today. It does have a potentially extremely chilling effect on regulation protection of the public. And what's so disturbing about this is that in North Carolina, we have board members that did not act in bad faith. They acted in good faith and asked for a cease and desist on an area of practice that had not been addressed by the legislature or policymakers at all. And the law and the legislative matters aren't always in a parallel path, and they're sometimes at odds because the law doesn't address everything. And in this case, the courts were addressing what they believed was not allowed under the law, but it was not disallowed either, and we had board members that were acting in good faith, but the court didn't have the authority to necessarily recognize that and rule in favor of the board members. So I think it's very appropriate that we're taking a look at this from a legislative point of view and seeing what needs to be in place policy-wise so that we make sure that we have board members who are protected when they're acting in good faith on behalf of the public.
Good. Thank you, Senator. And just my closing comments, thank you all for being here today. Thank you to the Assembly and to the tremendous BNP staff that they have, and to the great staff of the Senate BNP and Economic Development Committee for arranging the details of this committee. And thanks to the participants. We're going to be working together collaboratively with the stakeholders and certainly the two committees working from the Assembly and the Senate to kind of see where the best course of action for us and legislatively next year to make sure that we can resolve the issues and provide the protection that's necessary for our board members, and also allow them the opportunity to protect the consumer as they have been doing, and to make sure that we can move forward with that. So thank you all for coming. The hearing's adjourned. Thank you.